States of the United States, the great state of Florida, and the Honorable Court.
Be seated. Good afternoon, ladies and gentlemen. We have two cases on the docket, and we'll take them in the order that they appear. Mr. Parks, you ready to proceed?
May it please the court, counsel. Good afternoon. My name is Darrell Parks. I'm with the law firm of Parks and Crump in Tallahassee. I have with me Associate Jerry Lyons, who also participated in this case as well. I'm trying to get over a little cold, so if you'd please indulge me, I'd appreciate it. We're here today on a case that I just really believe is an outcome that was not in the best interest of justice. And it's important that this court understand the posture that this case found itself in. In late 2008, the plaintiff was faced with a deadline. We filed a motion to extend the deadlines in this particular case. In February, an agreed order was agreed to by all of the parties. That agreed order is important because we knew that we were at a posture that we needed more time for our expert and to do more discovery. With the agreement of the parties and the sanction of the court, an order was entered on February 12th of 2009. Now, we believe that a lawyer should be able to rely, if you have new deadlines that have been established with the parties and with the court, that those deadlines will apply. And in this particular case, April 15, 2009 was the new expert witness disclosure date, and July 30th, 2009 was the new date to end discovery. Well, to our surprise, shortly after that, around the 23rd of February, we received a motion for summary judgment, as well as a motion to take judicial notice of their intention to use a certain standard at the hearing. Well, we were still in discovery. For example, on March 12th, one day before the motion for summary judgment hearing, we had the deposition of Ms. Pennerman. And so that was very, 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 very important because we find ourselves still in active discovery in this particular case. Now, the standard for the motion for summary judgment proceedings here is de novo. We initially sued on 4 different premises: failure to warn, negligent maintenance, negligent design, and general negligence. At the hearing, and the hearing is very important because there is an allegation made that we did not ask to continue the hearing, or we didn't ask that the proceedings go on. Well, on 2 different instances, on page 39 and page 30 and 49 of the transcript, it is very clear that the associate from office asked, we believe that we still have an opportunity to have an expert to review this type of case. And that's important because in a road shoulder case, having an expert witness, especially a civil engineer, is so important because they need to review all the documents that are there. For example, even in this case, the state of Florida doesn't even rely on just its own engineers. It has Greenhorn and O'Mara involved in this case for their expertise. So the expertise of an expert becomes so critical in that particular case.
What would be the topic, though? I mean, because would the topic that you would have proposed, I know you did eventually file an affidavit, but are we talking about whether the drop-off at the construction site was in compliance with the manual, or are you talking about something involving causation, or?
Well, that's, and Judge Conn, I think in this particular case, they attempt to almost what I believe construe the standard in a different way. What the standard does, as Mr. Glennon points out in his inquiry, it just gives you a basic benchmark to go from. It's not a negligence per se situation, meaning that if you hit 3 inches, there's no way they could be negligent.
That's why I'm asking the question. I mean, would you envision having an expert that says, well, 3 inches is still dangerous, and let's leave sovereign immunity aside for a second, because I think they, at least the department, won on the grounds that following these design standards is discretionary, and you, I'm sure, take issue with that. But I'm just trying to, in my mind, think of what that expert would have said that would have made this hearing different.
And excuse my paper shuffle. I had it all laid out. You look right in here, right behind this affidavit, there's a sheet that looks just like this. It says safety impacts of edge drop-offs. If you go to the second page, and at the bottom of it, it has page 124. It says the threshold should be no higher than 2.0 inches. And even then, it says that you have to take it in perspective as you do your full analysis. Now, the analysis covers many other things. You can talk about the type of substance next to the shoulder, the speed in the lane, how the traffic approaches the drop-off. Those are all things that would have to be considered. So that's why this particular case becomes so important when it comes to expert testimony.
But are you telling us, really, are you really telling us that once the traffic, the homicide, this wouldn't have been a homicide investigation, although the investigator that did it may well have been a homicide investigator. Once the investigation's done by FHP and the witness statements are obtained and photographs are made and measurements are made, what else would an expert have needed to offer such an opinion?
Well, it's what we already know, Judge Kahn. For the good work that the Highway Patrol does, they're not a civil engineer. Okay, and that's why you need a civil engineer.
Let me stop you there, but I mean, I know change over the years, but my recollection is that oftentimes when you get to the accident scene, even just a month or two later, you often have to rely upon the measurements taken by the trooper.
Well, you can still take his measurements, but even then, my expert says that it was still a dangerous condition.
That's my point, though, Mr. Parks, is what would a hypothetical expert have needed back a month before the summary judgment hearing that he or she didn't have a month before?
Well, no, he wasn't hired yet. We were in the process of hiring this particular expert. We had another expert that I consulted with that I chose not to go with for other reasons. We hired Mr. Glennon, and you notice that we were able to at least get his affidavit
But you agree that under the rules of civil procedure, you got to file, as the non-moving party, you got to file your response generally, all other factors aside, you got to file before the hearing.
I agree.
And absent, and I don't have the transcript in front of me, the day is shortly coming when electronically we will have it in front of us, but absent some sort of attempt by your associate or your firm to get out from under that rule of civil procedure, you would concede that you all went into the hearing. At the time that hearing started, there was no opposition to the defense sworn allegations.
I agree with that, but however, Judge Kahn, there was an agreed order in place that gave me time to get my expert, right? And so I was in the process of getting my expert.
I'm sorry, go ahead.
We understand all of that, but did you ever formally ask the trial court to continue the summary judgment hearing?
Not in those words, Judge Webster.
Did you ever ask the trial court formally to continue the summary judgment hearing?
If I could read to you what I've marked out from the transcript. And here's how we addressed that. On page 30 of the transcript, here's what we say. Your Honor, in this action, discovery is still ongoing. There's still facts going on to be found. Also, we have not even met our expert disclosure date, Your Honor. We feel that once we meet those expert disclosure deadlines, which I believe is April 15th, that this court has just said, we will be able to show record evidence that his drop-off has some type of causal connection to this accident that took place. So although we don't use the words motion to continue, we are saying to the court that we're a month away from having to disclose our expert. We've engaged someone. He's looking at it. And it's important in this case, Judge Webster, we fought with Greenhorn and O'Mara to get some records and to try to organize looking at.
Well, Mr. Parks, let me tell you what my concern is. Rule 1.510 is very clear when it says that any supporting affidavits in opposition to the motion for summary judgment have to be served and filed before the hearing. And you didn't do that, and you didn't file a motion before that deadline saying discovery is still ongoing, please continue the hearing until we've had a chance to complete discovery. Why aren't you out of luck?
Well, I think now there are other standards that apply in the motion of a summary judgment hearing other than just move to continue. I think the status of the discovery before the court also plays a role in it. For example, there are multiple persons who had not been.
But I think the import of Judge Webster's question is that under this summary judgment rule, which has been in effect for many, many years, if you show up as the non-moving party, it don't matter whether you're the plaintiff or the defendant. If you're the non-moving party and you show up without making any contest to the sworn allegations of the moving party, it seems like you have an initial problem there that you have to ask specifically for relief from to the trial court. No matter, I'm sure we don't disagree with some of the general allegations you're making, but in terms of that rule, it's been long established that you have to provide the moving party with notice of what contest you're making of their factual allegations. Not having done that, don't you agree that you have to ask very specifically for some relief from the trial court?
I agree, Judge Kahn, you do have to specifically ask for some release, but I think if the court considers what's on page 30, line 11, and goes through page 31, line 9, and then is repeated on page 49, line 17, where we...
Well, let me just suggest this, and I've seen this done, is that counsel himself or herself files an affidavit timely under Rule 1.510 and says, this is what we have done in all due diligence to obtain an expert, yet we have not yet been able to do it. And I've actually seen situations where summary judgment's denied on those grounds, although arguably it could still be granted. But this record doesn't show that either.
No, it
Only
doesn't, Judge Kahn.
representations of counsel, and I fear that the case law is pretty specific that representations of counsel, either to procedural or substantive difficulties, may not. I want to ask you a question about the venue, because I assume you're not conceding, and if you are conceding, okay. Let me ask you about the venue, because, I mean, this order skates on a little bit of thin ice in terms of saying that the state can waive its venue privilege and thereby take away your right under Chapter 47. That may be a vulnerable order. But on the floor of nonconvenience, it seems to me like there's at least two cases, one of which is our Levy County case, and the other which is the 5th District's Eggers case, that seem to say when the party moving comes in with factual allegations concerning convenience of the parties, and it's not rebutted by the other side, that it's an abuse of discretion not to change venue. Do you disagree with that? In other words, they bring in affidavits from everybody and their uncle. I mean, they got eyewitnesses from Okaloosa County, Santa Rosa County, they got troopers, they got deputies, all these people saying it's going to be the end of our lives if we have to drive 150 miles to Tallahassee. Now, that may have sounded silly to you all as plaintiff's lawyers, but the case law seems to be that where that is uncontested by any evidence, the trial court must grant the motion, and I'm citing these two cases, Eggers and Levy County, to have you respond to that.
I disagree in that is not the law. In that, number one, the plaintiff has the presumption that the venue is proper, number one. Number two, the defendant has the burden of proving that we brought it to the wrong place.
It's not the wrong place, though. The law in Florida, which we have stated in Levy County and the other DCAs have stated, is that the trial court retains a great deal of discretion on changing venue. You have the privilege, you have the option, which is why I said I think the trial court's order may skate on thin ice to the extent he said, oh, you can't even bring this case in Tallahassee. I don't think that's right, but...
Although you didn't write the opinion in Diamond, Your Honor.
It's not my case.
But you sat on the panel. On that panel, I think it appears that Judge Gary didn't go far enough in his analysis of the total facts. For example, there are 5 affidavits.
But let me stop you again. The total facts in this case, you may not like them, I may not even like them. They may not like them, but the total facts in this case is that every affidavit presented to the trial court said, hey, it's going to be a really bad thing for us to have to go to Tallahassee. That's all I think it was Judge Santuri had. I may be wrong about
Judge Gary.
In Santa Rosa.
Oh, in Santa Rosa, okay.
I'm back to this case. I ain't on Diamond. That's all he had in front of him. You got this Eggers case out of the 5th and Levy County out of this court, Diamond, suggesting it may be an abuse of discretion not to grant the motion. That's what I want you to respond to.
I think that if I understand the question correctly, I think he did abuse his discretion in this particular case, in that had he looked at the witnesses that are there. For example, there were 5 affidavits, and he should have went into the substance of what the testimony would be. For example, the trooper... What connection to the Second Judicial Circuit did your side show? I guess maybe I'll ask it from the other way. What connection to this circuit did you all show factually at that hearing? One, that the Department of Transportation, headquartered here, waived. Number 2, all of the occupants in my van were from here. Not living here. But they were students here at the time. They weren't living here at the time of the hearing, were they? No, they were not, Your Honor. Some may have been here, so I can't represent to the court that they all had left. But some were still here because there were students matriculating at the various schools. But there were 4 van loads of students, right? He gave no consideration whatsoever to the fact. He didn't say that, no, maybe they had moved away. That wasn't part of his analysis. So his analysis was dead set on those 5 affidavits and not on the Bahamian students, which we made him aware of, and that they were here going to school and they had connections here. That has to play some weight. They have connections here in Tallahassee.
Can a trial court rely on oral representations of counsel in a situation like that, or do they have to be in the form of affidavit?
For the plaintiff's filing it's presumed to be true. So the plaintiff, the burden was not on him.
And did you allege in your complaint that these students all were going to school and living in Tallahassee?
Yes, sir. They were part of the rhythm rushers from Florida A&M University, Your Honor.
But you allege that in the complaint?
Yes, sir.
You're deep in your rebuttal time. I don't know if you want to go ahead and close now or reserve.
Oh, I'm sorry. I didn't see the light on. I'll save some time. Thank you, Your Honor.
Good afternoon. May it please the Court. My name is Kevin Franz.
Mr. Franz, will you please tell me whether, seriously, you think that the Department's waiver of venue privilege stripped the plaintiff of their right to select appropriate venue under Chapter 47?
Well,
Seriously now.
Judge, I think they obviously have a right to waive it, and if right to waive their home venue privilege, which they did, and then you look under 768.21, which gives
I understand your argument. Under Sub 1, it gives you the exceptions, and you know as well as I do why the legislature changed that statute, because the use of the venue privilege under Carlisle had become very burdensome to plaintiffs around the state. But I'm having trouble as a lawyer, a person who used to be a lawyer, understanding how your client's waiver of a privilege affects their substantive rights. I'm not getting that.
Well, I don't think necessarily does, because under 47.011, they can still bring it where the cause of action accrued. But, Your Honor, if you believe that they did not waive it, that is still okay in upholding the lower court's decision, because if the lower court correctly transferred
Yeah, I'm not even there yet. I'm just sort of, and I realize I know you apparently have a contract. You're not a DOT lawyer, I don't think.
I represent GAC.
GAC. I'm sorry, I'm asking the wrong person.
But then that's okay, because I've prepared
I
for
get
that
completely
issue.
confused about it. Okay, well, I apologize then, and I'll get on Ms. Longoria then.
But, Your Honor, if either decision to transfer based on former nonconvenience or under the waiver is upheld, then transfer is correct.
Let me ask you what appears to me to be a more fundamental question. Assuming summary judgment was properly granted, why should we care about the venue issue?
I think that's a completely valid question. I don't think there's any prejudice. I don't think it would make a difference what court the summary judgment was granted in, whether it was Leon County or Santa Rosa County.
Because clearly they both had jurisdiction, I assume.
Yes. I completely agree with Your Honor. I think the venue question is not as important or at issue in this case. This case is really about failure to preserve the issues on appeal. Judge Hawks, you said in Holland v. Cheney Brothers, with regard to preservation of issues, the court will not consider arguments which were not presented in a meaningful way to the lower tribunal. And everything that was argued on behalf of Brown falls into that circumstance. The decision to go forward with the summary judgment hearing, first of all, that the decision to do that is under an abuse of discretion. There's 4 reasons why this court should find that it was properly heard. Number 1, Brown did not preserve the issue for appeal.
Well, Mr. Parks has told us that he believes that the statement he read us from the transcript was sufficient to put the court fairly on notice that they wanted extra time to respond to the summary judgment request.
I respectfully disagree with him, and I think that it's insufficient. In fact, the rules, Rule 1.510F, the Florida rules specifically state that you have to file a motion to continue and you have to file an affidavit. In the cases that I've cited for the motions for continuance is Steiner v. Sibajigi and Levin v. Philly State. It simply said that the appellant cannot complain on appeal that the summary judgment went forward if it failed to file a motion to continue the hearing. Under Pereira v. FP&L, the court said you must show by an affidavit the existence and availability of other evidence, its relevance, efforts taken to produce it, and that any failure to do so was not your own fault. This court in Demesme v. Stevenson simply said the appellant failed to attach an affidavit to its motion to continue, and this court affirmed the denial of the motion to continue on that basis. So not only do we not have a written motion to continue, we don't have an affidavit either. There was no or attendance motion to continue the case. At no point did they ask for a continuance. In fact, they responded to the written motions for summary judgment with a response, and at no point in that response did they ask for a continuance. There was no pending motion there were no depositions set to take place at the time the summary judgment hearing was scheduled or at the time it was heard.
Mr. Parks says that the discovery deadlines that had previously been set had not yet passed as of the date of the hearing. Is that correct?
That's correct, Your Honor. But it's still under the Florida rules that are clear-cut. They have to move for a continuance, and because there's an order, it doesn't defeat that. They can't. So basically, the fault here for not completing discovery or not preserving the issue solely falls on Brown in this case. As an informer, the form nonconvenience, it's the same exact story. Like Your Honors understand, under Eggers, both parties are required to file affidavits. Yes, it's the movant's burden, but we filed 5 separate affidavits of 5 people who all testified as to inconvenience and all testified as to the gist of what they would testify to in court. The plaintiff then, Brown, has the obligation under these cases, it's very clear, that the plaintiff has to come forward with counter affidavits. The court cannot consider mere argument on the record as to stand for actual evidence. The cases are very clear on that. So they simply cannot be heard to complain on appeal that it was error to transfer. This Court, I wholeheartedly believe, cannot find an abuse of discretion in transferring when there was no counter affidavits presented below. And again, I come back to the Holland v. Cheney brothers when they said this Court will not consider issues that were not raised below, and that's exactly what we have in this particular case. Your Honor, I prepared a lot more, but I don't think that there's any other questions substantively. The only thing I can add with regard to the 3-inch drop-off and the warning signs is that the lower court took judicial notice that the MUTCD guidelines is what controlled the duty under this case. There was no objection from Brown when the court took judicial notice. They asked if there was objection. There was no objection. Under Payne v. Palm Beach County, the court said that the duty was met when the placement of the warning signs met the requirements of the MUTCD in a car accident case. So I don't think there's any question that if GAC presented evidence to show that the drop-offs were 3 inches or less and that the warning signs were, in fact, in place, that summary judgment should have been awarded to GAC as it was. The plaintiff, Brown, has brought forth no evidence to suggest that warning signs were not in place, and no evidence, none, to suggest that the drop-off was 3 inches or less. We presented a plethora of testimony. Gary Barnes is a foreman for GAC. He did daily inspections and daily measurements. He even took Polaroid photos, which I've attached as Appendix 1, and wrote on them, before he knew any sort of liability, he wrote 2.5 inches. That's the day of the accident. Charles Foster is an independently hired entity, Greenhorn and O'Mara, by FDOT, to make sure that GAC complies with the duties under the MUTCD. And this is unrefuted, the day before the accident, he wrote a letter saying that the drop-offs were within the 3-inch requirement. There's no counter evidence to suggest any of this is not accurate. And Officer Joe Powers, who went there the day of, looked at the MUTCD guidelines, measured it, said it was within the guidelines. There's simply no evidence to counter that. As to the warning signs, Jim Haney, who was the GAC project manager, and John Meyer, who was the GAC project engineer, both testified as to the warning signs. They stated 9 warning signs were in place at the time of the accident. Warning of road work, construction ahead, reduced speed limit, uneven lanes, trucks entering the highway, and rest area closed. I've attached those as Appendix 2 to the motion. They are not the best quality, and I have the original photographs if Your Honors would like to see them. But in any case, it's simply not disputed that those show the signs were there. Therefore, there's really no dispute that the warning signs were in place either. Any question as to these warning signs were raised in the motion for rehearing, and the lower court correctly said just because they can't recall whether they're there, it doesn't create a genuine dispute of fact. So, Judge, I would respectfully request that all of the lower court's rulings be upheld. And as far as anything having to do with the FDOT, I would respectfully cede my time to co-counsel unless you have any further questions. Thank you, Your Honors.
May it please the Court, my name is Diana Longoria. I'm here representing the Florida Department of Transportation, and
Can I ask you my question? And I do tend to agree with Judge Webster that the summary judgment is important here, but is it the official position of the state of Florida that Judge Gary is correct when he says the only proper venue in this case was Santa Rosa County?
Well, I understand the issue that you raised with co-counsel about that, and but I also understand Judge Gary's decision and the wording that he used.
He's made wrong decisions before, though.
I'm sorry?
He's been wrong before.
I'm sure we all have.
I'm not asking you whether you understand me.
Yeah.
You know what I'm asking you. I'd like
I
to
know what
know
you're
because I've
asking.
never had this issue come up before.
Mm-hmm.
And I understand how it comes up because everybody knows that this venue thing goes wrong with sovereign immunity, and under 76828, the law is that the waiver of sovereign immunity is only to the extent the legislature has waived it. So I understand the argument, but I got a little problem with the result, and that's why I don't want you to spend a lot of time. I just want to
And I don't
know
want-
if you think if that was the only thing you had was his statutory construction, if that would be enough to win the day for you on venue.
No, Your Honor, I don't. But I would rely on your recent case in Diamond, Levy County versus Diamond, which was recent, was a 2009 case, where the First District held that the waiver of the home venue privilege by a state entity, in that case it was the DEP, in combination with a motion for transfer of venue for the convenience of the parties. In that case, it was also very similar to the case we have at hand in that the plaintiffs could not show any strong connection to the forum venue. And with that set of facts that is similar to our case, along with recognizing that the state, the DEP, had waived its home venue privilege, it was an abuse of discretion not to grant the motion in that case. I think it's very similar. The Diamond case is very similar to the case we have at hand. I know it sounds like I kind of dodged your question about whether or not Judge Gary was correct in relying.
I'm satisfied with your answer.
Oh, good. Well, then I'll leave it there.
Sometimes discretion is the better part of valor.
Absolutely.
Yes, I
And we
agree.
remember that when counsel's forthright. We remember that.
All right. Well, that's good. If I'd like to reserve the rest of the time unless the Court has any questions or issues in the forefront of your mind with regard to the DOT's position. We'll reserve the rest of our time for rebuttal. Thank you.
No cross appeal.
First and foremost, if the court would look at the affidavit of Kamal Cooper, in his affidavit he said that the drop-off was about 3 inches. There's a reason that the word about was used. It could be greater, it could be lesser. And so if we are entitled to any presumption, then we win that battle right there, and summary judgment should not have been entered. Number 2, we timely filed a motion for rehearing and applied all of the affidavits where he identified that it was an ultra-hazardous condition. So the judge's ruling on the motion for rehearing was improper, and we should have been allowed to have our day. The affidavit was in there and was there for his consideration. Number 2, the court should not gloss over some of the things that they have said to you. For example, they mentioned there was no evidence to counter the 3-inch drop-off from the February 19, 2004. This letter was actually about the site having an asphalt failing gradation test. I want to talk just a little bit about a few of the witnesses that they've said are so key in this case of this so-called wall of evidence. For example,
Which affidavit did you just show us?
that was not an affidavit, that was the letter.
Letter. The letter, one of Haney's letters? Foster's letters? Or?
Letter of Eric Rosenstein with Greenhorn and O'Mara dated February 19, 2004. That was alluded to that they measured the day before there was a 3-inch drop. Well, it says a lot more that was going into it. But also, those same letters that they talk about that happened on the site talk about drug use on the site, false things by... I understand.
Mr. Parks, we walked the last mile, and we understand summary judgment, but that may be one of the extraneous exhibits in this case. I don't quite recall whether it's one of those, but that's got nothing. Could that possibly have anything to do with this case? That somebody complained about another employee maybe using drugs?
What I
Could
would
it
ask,
possibly have anything to do with this case?
and I'm moving on past that, Judge Kahn.
But I mean, that's a yes or no. Could
It has nothing to do with it.
Okay.
Nothing to do with it. But I think the court will look at the witnesses that they have put in this case. Mr. Falston, he never saw the accident. He wasn't there. Richard Dodd, he was not a witness to the accident. Mr. Jim Haney, he was not a witness to the accident. John Meyer.
But surely you're not suggesting that these people would not likely be called by the defense at a trial. It doesn't matter whether they saw the accident, does it? What matters is whether they're likely to be witnesses at the trial.
But it also matters, Judge Webster, whether their testimony will be material to anything that happened that day. For example,
isn't testimony regarding how high the drop-off was relevant to what happened that day?
on the day of question, Judge Webster, on the day of question, they can't come in and talk about all the things they did previously, just like Judge Kahn told me we can't talk about the letters from the previous year. They can't come in and talk about the drop-off back in January. We got to talk about what happened that day. In this particular case...
And you don't think these people would be able to testify what the drop-off was that day?
Two people saw it from their side. Mr. Greg, there was one employee there who measured it, and the trooper. Those two saw it. But when you look at the testimony of the trooper, right, his testimony was he does not remember what the exact specifications were, but he thought it was within specifications.
Was there some evidence that the drop-off was changing on a regular basis?
Yes, there's some evidence of that. They continually had to work on the drop-off.
In what affidavit does that appear?
Well, this in no affidavit. Well, the work is in the testimony. It's not in an affidavit form, but in deposition testimony, one of the things that GAC had to do was to work on the shoulder if there were problems with the shoulder from accidents or in previous cases. One of the hard things about this case, and the reason the discovery was so important, is that we were learning this information.
Mr. Parks, I think you're out of time, and appreciate your argument.
Thank you so much.
You're welcome. And that's this case. There was no cross appeal, so there's no rebuttal. But so we'll call.